Good morning, everyone. I am Julie Rowine, President of the League of Women Voters of Concord-Carlisle, and on behalf of our league, I would like to welcome you all to this latest iteration of our First Friday series. Our next First Friday will be on June 4th, and then we will probably be on hiatus for the summer, so join us in June. This morning's topic is the open meeting law, a subject near and dear to the hearts of many league members and other people. Since our founding in 1920, the League of Women Voters has worked to foster civic engagement and enhance access to voting. The League is a nonpartisan organization and does not support or oppose any candidate or political party. This morning's program is being recorded and will be available on our website. And I will now turn the meeting over to Diane Proctor, Chair of the LWVCC Concord Town Government Committee, which organizes our First Friday series. Diane?
Thank you, Julie, and welcome everyone. I'm going to be give you a little bit of the background. First, I'm going to introduce our speaker, Carrie Ann Kilcoyne. And then, and Carrie, when I say that, I'm right back in Ireland, and I'm doing my Limerick accent comes flying out. Carrie Ann, and then she's going to give her presentation. Carlin Reed will be monitoring the chat box, so as questions come up, please put them in the chat box. As well, after Carrie has spoken, the League has formulated some set questions, which Tanya Bartavian is going to be presenting to Carrie. And then Carlin will present the questions that the participants have from the chat box. If we have time at the end of that, and there are additional questions that Carlin has not called, or Carrie has not answered, or Tanya has not asked, we very much welcome participation from all who are here. Let me introduce Carrie. Carrie Ann Kilcoyne is the Assistant Attorney General in the Division of Open Government in the Office of the Massachusetts Attorney General's Office. Carrie has been with the Attorney General's Office for 4 years. Prior to joining the Division of Open Government, Carrie was an Assistant District Attorney in the Appeals and Training Bureau of the Middlesex District Attorney's Office for 12 years. Carrie also worked as a staff attorney in the Public Records Division of the Secretary of the Commonwealth Office for 4 years. Carrie's a graduate of Assumption College and Suffolk University Law School, and she brings a breadth of knowledge, experience, and background to this discussion. Carrie, welcome, and thank you for joining us.
Thank you so much, Diane. Good morning, everyone. Happy to be here this morning to present on the open meeting law. Before we jump into the open meeting law, generally, we just want you to know that the Attorney General's Office serves the residents of the Commonwealth, but also state departments and officers and commissions and other groups of consumers through, various ways such as investigation, enforcement, prevention, and policy. If you have issues sort of outside of the open meeting law, we have this Public Protection and Advocacy Bureau that can help you with issues perhaps in your everyday life that you come across, including issues with work or landlord, mortgages, things of that nature. We are located throughout the state, although we are still currently working remotely. But I am generally in the Boston office when I am actually in a physical location. But we do have other offices in Western, Central, and Southeastern Massachusetts. So let's get right into the open meeting law. So, the purpose of the open meeting law is to strike a balance between government accountability and government efficiency. And so it requires government accountability by ensuring that public bodies are posting notice for every meeting, that those meetings are conducted in open fashion so that anyone can attend that meeting and be able to hear and see what the public body is discussing. But it also ensures government efficiency by allowing public bodies to manage their operations by providing that certain discussions can happen in a closed or executive session, and that certain documents or records that they may use in that executive session can remain confidential. Now, the Attorney General's role with respect to the open meeting laws is really first and foremost to educate public officials and public bodies, as well as the public, on the open meeting law. And so we do that through training such as this. We usually do offer in-person regional trainings, although last year and this year we've suspended those, but we are continuing to offer webinars. And you can check out our website for the next date and times. We have some scheduled through the month of June, but we will be scheduling through the rest of the year. We also promulgate regulations. We provide guidance on the open meeting law through both a telephone hotline and an email hotline. If you are able to access the handout, which is in the chat feature, you will find our contact information, and I'll show it at the end of the presentation. There's a slide with our contact information. So we do monitor that. Don't be dismayed when you have to leave a message, because we do monitor it frequently, and someone is on staff every day to check that. We generally get back to you within 2 business days. But we also have an email address that we frequently monitor as well. We also investigate open meeting law complaints whereby someone alleges that a public body has violated the open meeting law. And we would investigate and issue written findings. All of our determinations can be found on our website. We probably have over 1,000 determinations since we've taken over enforcement of the open meeting law back in 2010. Now, if you are a public body member, you are required to sign a certification form within 2 weeks of either your appointment or your election to that position. Excuse me. This is the form here. You can find it on our website. However, if you are a new member of a local public body, generally the clerk, the local town clerk, is going to be handing you hopefully a copy of the certificate. You also should be receiving our guide to the open meeting law, which includes the law itself and the regulations, or at least a link to where you can find that information on our website. And so basically, when you receive this form, you sign it and date it, and you are basically certifying that you have read and understood the requirements of the open meeting law and the consequences for violating it. And when you've read and understood, what we've given you for the materials, it's the guidebook, and it also includes the last 5 years of determinations that the Attorney General's office has issued where we have found a violation against your specific public body, so that as a new member, you're aware of where perhaps issues have arisen in the past, and so as not to continue and make the same mistakes again. So again, for a local public body, the municipal clerk would be providing this to you. For any other type of state public body or regional public body, whoever appoints you would be generally providing this information. You would return this form back to the individual who provided it to you. We do not need to receive a copy of at the Attorney General's office, although you should obviously or hopefully keep a copy for yourself in case there are any questions about whether or not you have complied with this specific aspect. So you need to sign this form every time you are reelected or reappointed, even if it's to the same public body. If you're joining, for example, a subcommittee, which I'll explain later, you do not need to sign this form. So as we proceed to talk about the open meeting law, there are some sort of basic principles that we want you to keep in mind. And the first of that is that notice for all meetings, both open and executive session, must be posted 48 hours prior to the meeting. All meetings must be open and accessible to the public. Minutes for all open and executive session meetings must be timely approved and maintained. And then finally, there's a complaint process whereby an individual who believes that a public body has violated the law can file a complaint and then perhaps request further review from the Attorney General's office if they're not satisfied with the response of the public body. And we'll go through all of these steps shortly. So the first important definition under the open meeting law is public body, because the open meeting law only applies to public bodies. So that is defined as a multi-member board, commission, committee, or subcommittee. However, it's created, elected, appointed, or otherwise constituted, that's established to serve a public purpose. This also includes a subcommittee, but generally a public body must have multiple members. So one individual public official cannot be a public body. It doesn't matter what the public body is called, whether it's called a committee or a board or a task force or a working group. If it satisfies this definition, it is considered a public body and it is subject to the open meeting law. Again, subcommittees are generally public bodies that have been created by another public body, a parent public body, to advise that parent public body on a particular matter. They are also subject to the open meeting law and must follow the same open meeting law requirements that the parent public body must follow, including posting notice and maintaining minutes. Now, there is an exception to this definition that's called the Connolly exception, which basically states that where a public official creates a group to advise that public official on a decision that he or she has the sole responsibility for, that group is not subject to the open meeting law. So what happened in the Connolly case was that the superintendent by law had the authority to recommend a candidate for principal to the school committee. And the superintendent decided that he needed assistance in making that recommendation. So he created a group to help him make that decision. And what the court said with respect to this is that because the superintendent had the sole authority to make that recommendation, and further, because the superintendent himself was not subject to the open meeting law, that any group that he created to help advise him would also not be subject to the open meeting law. So that's the distinction. It would be different if the school committee itself had the authority to recommend a candidate for principal, because there, the school committee is subject to the open meeting law. So any separate group that the school committee would create would also be subject to the open meeting law because the school committee is subject to the open meeting law. Now, there are some statutory exclusions to the definition of public body. One of them is the state legislature. So they wrote the law and they decided to write themselves out of it. So they are not subject to the open meeting law. Bodies of the judicial branch, such as juries, are not subject to the open meeting law. Generally, we have found that not-for-profit organizations, those organized under 501c3, are usually not subject to the open meeting law. Bodies that are created by one of the 6 constitutional officers, such as the governor or the secretary of state, the lieutenant governor, those types of groups would not be subject to the open meeting law. Bodies that do not serve a public purpose, so for example, a retirement planning committee, where their focus is really just on a private matter, it's not really something that would involve the public, those types of groups are not subject to the open meeting law. And finally, focus groups, where they're not really established with any one type of jurisdiction, they don't make decisions, they don't really act collectively. It's really just an invitation to attend a meeting, so to speak, and provide feedback on an issue that's of interest to this one group. And you see this arise in maybe neighborhoods, where neighborhoods portions of neighborhoods would get together to discuss an issue that would affect just them directly. Those are the types of groups that would not be considered a public body. So the next sort of important definitions are quorum and deliberation. And the definition of deliberation is an oral or written communication through any medium, including electronic mail, that's between or among a quorum of a public body on any public business within its jurisdiction. So whether or not the open meeting law applies, you need to look to see what the group is doing and whether or not it's deliberating. And so this definition is very broad. It covers any type of communication. So whether it's by phone, via email, could be text message, even social media. It encompasses all of that. And it has to be between or among a quorum. So what is a quorum? A quorum is defined simply as a simple majority of the members of a public body. So if you have a 7-member group, the quorum is 4. If you have a 5-member group, a quorum would be 3. So it's just a simple majority of the members of that public body itself. Now, there are certain activities that are written right into the open meeting law that are not considered to be deliberation. And one of those is the distribution of a meeting agenda. So prior to the meeting, members can distribute the agenda for the next meeting. You can discuss a scheduling or procedural type of information. So you could email, for example, other members of the public body to decide what is a good date for the next meeting. That would not be considered deliberation. You can share and distribute reports or documents to be discussed at the meeting. However, those reports and documents cannot contain the opinion of members. So you can send an email saying, attached, please find these documents to be discussed at our next meeting, but you can't in that same email explain the importance of those documents or your opinions about why you think they're important or exactly what you might be discussing with respect to those documents. So it's simply sharing the documents. You can have discussions among a sub-quorum. So you can have discussions among less than a quorum of members, which would not be considered deliberation. So again, if you have a 5-member public body, 3 is a quorum. Technically, you could have discussions among 2 members, that is not a quorum, and not be considered deliberation. However, just keep in mind that there is the potential for serial communication, whereby you talk to each other in some kind of serial fashion such that you reach a quorum. So if member A talks to member B, that's only 2 members, not a quorum for a 5-member group. But then if member B talks to member C and discusses with C the conversation that he or she had with A and B, now you've reached a quorum in a serial fashion, and it's very likely that you have deliberated outside of a meeting. So just keep that in mind. Now, the only caveat to this is that if you have a 5-member public body, again, 3 members is a quorum, but if you have created a 2-member subcommittee, anytime those 2 members of the subcommittee speak to each other, they need to follow the open meeting law, because a quorum of the 2-member subcommittee is 2. So anytime they discuss matters within the jurisdiction of the subcommittee, they are subject to the law and must post notice and cannot deliberate outside of a meeting. And then finally, any discussions about the recess or continuance of a town meeting in the event of a weather-related or public safety emergency is not considered deliberation under the open meeting law. Now, there's a lot of issues and we get a lot of questions about what can we do on social media. With respect to social media, what we look at is really the communicator's intent. That is relevant. So whether members of a public body are all on the same Facebook group is not in and of itself a violation of the open meeting law. Whether they simply see what another member has posted on a Facebook group, again, is not determinative and is not necessarily deliberation. But a communication that is directed at members of a public body rather than the public, that could be deliberation. If you're simply posting for anyone to see who is a member of that Facebook group, and no other public body member responds, even if they simply see it, you know, that's generally not going to be a violation of the open meeting law. A text messaging between a quorum of members, either during or outside of a meeting, could constitute private deliberations and be a violation. With respect to listservs, so public body members can subscribe, but again, to just be cautious that if there's a quorum of members on a listserv, there could be the risk of unlawful deliberation. Also, you know, discussions about a public body's operation, such as, you know, leadership of the public body, choosing who might be chair or vice chair or things of that nature, that is considered to be public business within the public body's jurisdiction and should be reserved for discussions during an open meeting. And then finally, public body members can share documents in an online Dropbox. But again, you know, you're limited to just distributing the meeting agendas or documents as long as those documents don't contain opinions, and as long as, you know, there aren't any discussions about the importance of those documents. So you cannot be sharing documents in which you're going to be editing documents and then discussing it at a next meeting. Any type of editing likely could be considered deliberation. So I would just be cautious about doing those types of things off, you know, without the public being able to see what the discussions will be. So sort of the final important definition is that of meeting. And what is a meeting? So it's deliberation by the public body with respect to any matter within the body's jurisdiction. There are certain exclusions, again, listed right in the open meeting law. One of those is for on-site inspection. So for example, maybe a school committee is going to be touring a new school. Just keep in mind that when it comes to on-site inspections, it's really limited to simply inspecting, for example, a piece of property. You shouldn't be having discussions about that property, and you shouldn't be having sort of back and forth questions and answers about it either. And we realize this is very limiting, but obviously our role is to advise you on how best not to violate the open meeting law. And there is some case law that suggests that even back and forth questions and answers among a quorum of a public body is considered deliberation. So again, an on-site inspection is where you simply go to the property, view it, and then perhaps return and meet in an open session and then have those discussions. I mean, if you want to be able to have discussions on site, you really would be required to either post notice if a quorum wants to attend, which we realize can be limiting because you might be in a location that's not safe for everyone to go out and walk around, or you send less than a quorum at a time, and then you reconvene in a posted meeting and have discussions among the entire group. Another exclusion is meetings of quasi-judicial boards. This is only for state agencies. So if you are a state agency, you can meet behind closed doors for the sole purpose of making a decision in an adjudicatory proceeding. Town meetings are specifically excluded under the open meeting law. So any questions with respect to town meeting, we just don't have the authority to answer because it's outside the scope of the law. A quorum of members could attend an event such as a holiday party or some kind of training session, a quorum of members can be together in one place. You shouldn't be standing in a corner together deliberating outside of a meeting about something that's within your jurisdiction. So you're simply attending to learn, or again, just a holiday party or some kind of retirement party would be fine as well. And then finally, members of public bodies can attend other public body meetings. So just because you're a member of a public body doesn't mean you lose the right as a citizen of that community to attend other public body meetings. Just keep in mind, if you see other members of your public body there, it's probably best not to sit together. And if you want to speak, you would simply speak as a citizen. If several public bodies want to get together and have discussions as public bodies, there's always the opportunity to post and hold a joint meeting. So I'm sure, as everyone knows, last year the governor issued an executive order which suspended certain provisions of the open meeting law, mainly with respect to remote participation. And what it now says is that all members of a public body can participate in a meeting remotely. So you don't have to provide physical access to a meeting location, as long as you provide access through adequate alternative means. So some kind of means so that you're broadcasting, however you do that, video, audio, YouTube, Facebook, Zoom, so that members of the public can follow the proceedings as they are occurring, that they can follow those live discussions. And we'll talk about this a little bit later. In a few more slides, we'll talk about remote participation. So, all public bodies, except in an emergency, have to post notice of every meeting at least 48 hours in advance of that meeting. And that excludes Saturdays, Sundays, and legal holidays. So those 3 days you can't use any of those days as part of the 48-hour requirement. So the notices have to include the date of the meeting, the time of a meeting, the place of a meeting, a list of topics that the chair reasonably anticipates will be discussed. And it also needs to include the date and time that the notice was posted. This can either be on the face of the notice itself, or it can be somehow an electronic stamp where the notice is posted. With respect to the topics should have enough information so that a member of the public who looks at that notice or agenda can understand the discussions that will be had and decide whether or not they want to attend. So, general topics such as old or new business, just broad topics like that, are usually not sufficient in and of themselves, but you could list those topics as sort of headers under which more specific topics would be listed. Now, public bodies are allowed to post notice less than 48 hours before an emergency meeting, but an emergency is really considered to be a sudden, generally unexpected occurrence or set of circumstances that demands immediate action. So even though you don't have to post 48 hours notice, you should be posting some kind of notice, however long that is. Even if it's only an hour before the meeting, you do still need to post notice. Generally, an emergency is going to include issues that relate to health or public safety. It's not because you forgot a deadline or something of that nature. It really has to be something that came up that you didn't anticipate, not something that you simply forgot or ended up being some kind of scheduling conflict. Now, how you post notice is a little bit different depending on what type of public body you are, but generally for local public bodies, you're either going to file with the municipal clerk and then to a separate bulletin board that's outside, because notices have to be available at all times. So you have to post, in some place that members of the public can see the notice 24/7. So inside a building that is closed for, most of the day is not going to be sufficient. If you don't have an outside bulletin board, for example, your alternative is to post to your town website. And we are seeing a lot of public bodies now simply posting to the website. The website has to be adopted first. Generally, it's adopted by either locally a select board, or if it's a city, by the mayor. Once you have adopted the website, please notify our office of the specific website address, because we do keep a list. And you can find that on our website as well. If you have adopted the website as your alternative posting location, you should also be giving a copy to the clerk so that he or she can still post a notice, in and around the clerk's office, so that anyone who enters town hall can see that notice. I realize that a lot of town halls might still be closed, so that might not be possible now. But when things get back to normal, that is, part of the requirement, that if you are choosing website, also file with the town clerk so that he or she can post. If you are a regional or district public body, generally you serve more than one community, you have to post in each city or town within your district in the same manner that you would for a local public body. So again, with the clerk, to an outside bulletin board, or as a regional public or district public body, you can choose the website. Excuse me, sorry about that. County public bodies, if they even exist anymore, post with the Office of the County Commissioner, or again, you post to a website. State public bodies only post to a website, either to the parent public body's website, or if the specific state public body has its own website. Again, just notify us of the website location, but you do not have to send a copy of the notice to our office. However, you do have to file a copy with the Regulations Division within the Secretary of the Commonwealth's office. So we do get some common concerns about posting, and one of them is, what if a new topic arises after the notice is posted? So public bodies, are not prohibited from discussing topics that arise within the 48 hours if that notice was not anticipated by the chair. So you're not prohibited from discussing a topic simply because it's not on the notice, especially if it arises and it was unexpected. Best practice, and we certainly encourage public bodies to revise the notice if a topic does come up within the 48 hours, so that people are aware that you will be discussing an additional topic. What if the clerk can't post notice in time? So the responsibility for posting lies with the public body. So we encourage chairs of public bodies to work with your clerks if they are the ones who are posting the notice, to make sure you understand what the time frame is for posting, whether or not your clerk's office might be closing early on a Friday and you need to get it in before that time so that it can be properly posted, because we consider the notice to be properly posted when it's actually published, for example, to a website, not when it's simply received by the clerk. Canceling a meeting does not require 48 hours notice or any type of notice. We certainly encourage public bodies to post some kind of notice if you are canceling a meeting, just for transparency purposes, but it's not specifically required. Meetings that are going to be continued to the next day, however, do require 48 hours posting. So if you are meeting on a specific day and it's getting late, but you haven't finished your agenda and you want to continue to the next day, you cannot do so unless you have posted 48 hours prior for that next day. So you can't just continue to the next day if you haven't previously posted. We understand that there might be additional posting requirements if you're holding a public hearing. Those types of questions are really outside our jurisdiction, so we unfortunately can't provide you with any guidance about additional rules that may apply for posting notices for public hearings, which might require a longer posting period than the 48 hours. If you are posting to a website, we just want the notices to be easy to find, either listed on one central page like a calendar page or on a public bodies page. If you can avoid posting in multiple locations, that's best practice, just so that people aren't clicking around and finding a hard time. Just make the notices as easily found as possible. If you have a website outage and the website is not available or all the notices are posted, you have 6 business hours to fix that website. So if, for example, the website goes down at 2 a.m., but you don't come in, office hours don't start till 8 a.m., that's when you've discovered the outage. You would have 6 hours from 8 a.m. to fix that problem. If it can be fixed, you're good to go. If it can't be, then any notices that were posted or any notices that are meetings that are occurring within the 48 hours of that outage should be canceled. Now, again, meetings have to be accessible to everyone. That includes those with disabilities. If you have any questions about whether or not your facility complies with those types of rules, you can reach out to our Civil Rights Division. But you do have to make reasonable efforts to make sure that everyone can access the meeting location and that people can see and hear the discussions that are happening. So there's no specific restriction on meeting in buildings that have some kind of security protocols in place. For example, perhaps you need to provide some kind of identification before you get into a building. That's fine. You should, for transparency and openness purposes, just post on the notice that perhaps you might need to bring some kind of identification so that people know ahead of time that they need something in additionally to get into a building. So here specifically with respect to remote participation, again, you don't need to first adopt remote participation under the governor's executive order. So now any and all members of the public body can participate remotely. There is no requirement at the moment, as there was previously, that a quorum of the public body, including the chair, be physically present in the location of the meeting itself. If you are participating remotely, again, everyone at the location, you want to make sure you're clearly audible to everyone. And if everyone is participating remotely, they can still vote. You're not deemed absent just because you're participating remotely. The type of technology that you want to use if you're holding remote meetings is up to the public body. You can decide what type of platform to use. However, members who are participating remotely have to notify the chair. The chair has to make an announcement at the beginning of the meeting of all the members who are participating remotely, even if it is every member of your public body, there has to be an announcement. All votes that are taken during a virtual meeting have to be by roll call and have to be listed as such in the minutes. If you're distributing documents, it's helpful to do that ahead of time. If a public body is going to be meeting in executive session, every individual meeting remotely has to make some kind of announcement that no one else can overhear, that no one is present to overhear those executive session discussions. Again, acceptable methods of technology are any kind of telephone, internet, or satellite enabled audio or video conferencing, anything that allows individuals who are participating to hear each other. And finally, if any technical difficulties arise, the chair would decide best how to go forward, whether you take a recess to fix those difficulties, or you decide to simply adjourn the meeting. If anyone is disconnected from the meeting, there should be a notation in the minutes of who was disconnected and the time that disconnection occurred. Now, with respect to, public participation, anyone has a right to attend an open session meeting, but they don't have a right to actually speak during the meeting. Whether or not you can speak during the meeting is within the discretion of the chair. So you cannot address the public body without the permission of the chair. If you continue to talk without that permission, you must be given a warning. If you continue to disrupt the meeting, you actually can be removed from the meeting itself. Anyone who attends a meeting can make an audio or video recording of an open session. You just have to notify the chair that you are making such a recording. You cannot be prohibited from making that recording. It's just that once you notify the chair then has an obligation to make an announcement that the meeting is being recorded. And moving on to executive session. So their public body can meet in executive session for 10 specific purposes. I don't think I'll go over each purpose because I want to leave enough time at the end for questions. So I'll go over some of them that seem to come up more frequently than others. But prior to convening an executive session, there are certain procedural requirements that a public body must follow before entering executive session. And you have to convene, the first one is to convene an open session. Then the chair has to state publicly the purpose for the executive session with as much detail. So either stating the exact language that's written in the open meeting law, that purpose again has to be stated prior to convening an executive session and also should be on the notice as well. There has to be a roll call vote taken to enter executive session first. There also has to be an announcement in open session that the board will either reconvene in open session at the conclusion of the executive session, or whether the public body will simply adjourn from that executive session. Again, there should be a statement by any remote participants that no one else is in the location and can overhear the conversations. All votes that are taken during an executive session have to be by roll call, even if they are unanimous. Make sure that any documents are maintained that you use during an executive session, and make sure that the executive session discussions focus specifically on the purposes that you have announced for convening an executive session. So even though a matter might be appropriate for executive session, if you have not made an announcement that you are going to have such discussion, you cannot have a discussion on that topic in executive session. So let's get into some of the executive session purposes. Purpose one allows the public body to discuss the reputation, character, physical condition, or mental health rather than the professional competence of an individual, or to discuss the discipline or dismissal of or complaints or charges brought against a public officer, employee, staff member, or individual. So this executive purpose does not allow the discussion of professional competence or employee evaluations. You cannot do that under this purpose. Those kinds of discussions have to be done in open session. The other types of discussions, as I stated, that you can have an executive session require that the individual about whom you're discussing, so if you're discussing the discipline of a particular individual, that individual has certain rights. And one of them is to be notified in writing at least 48 hours prior to the meeting of this proposed executive session. The individual has the right to require that that meeting be held in open session rather than executive session, and the public body has an obligation to abide by that request. The person has a right to attend the executive session and speak. They have a right to bring someone with them, mostly for the purposes of advising that individual and not speaking on their own. And they also finally have the right to cause an independent record of that executive session to be created, either by recording or transcription. Purpose 2 allows the public body to conduct strategy sessions in preparation for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. So this is sort of a three-parter: strategy sessions to prepare for negotiations with non-union personnel. Second part, to conduct collective bargaining sessions with union personnel. Third part is to conduct actual contract negotiations with non-union personnel, which could join the public body in the executive session. When you are discussing contract negotiations, again, there's a presumption that professional competence and evaluations have already been completed. That cannot be done in executive session. How that evaluation affects the contract is okay. Those types of discussions are okay. When you are negotiating a non-union contract, if you reach an agreement, you have to vote to execute that contract in open session. So you can agree on terms in executive session, but the actual execution of the contract must be had in open session. The public body should be identifying the specific non-union personnel with whom, or collective bargaining unit with whom it will be negotiating prior to entering into executive session, unless the disclosure of that information would somehow compromise the purpose for secrecy. We generally defer to the judgment of the public body on that, but the public body has to, show some kind of reasonable basis for making that claim if they're challenged. Purpose 3 is to discuss strategy with respect to collective bargaining or litigation if an open meeting would have a detrimental effect on the bargaining or litigating position of the public body and the chair so declares. Here, the chair specifically has to make a declaration that deliberating during an open session would have a detrimental effect. If you're discussing a litigation matter, that must be pending or imminently threatened. So just because someone has an attorney doesn't necessarily mean that litigation is pending. The public body can be discussing, litigation or a lawsuit that has been filed against it, or could discuss filing or initiating a lawsuit. That would also be an appropriate discussion under this purpose. Here, unlike purpose 2, if a public body is discussing collective bargaining, they can approve final terms and execute the agreement in executive session, but they should disclose in either their next meeting, or if they're reconvening an open session, the agreement that they have reached in executive session. And again, the public body should identify the litigation matter or the collective bargaining unit with whom they will be negotiating prior to convening an executive session, unless disclosure of the information would compromise the purpose for secrecy. I'm going to skip over 4 and 5 because they're not widely used. Purpose 6 is to consider the purchase, exchange, lease, or value of real property if the chair declares that an open meeting would have a detrimental effect on the negotiating position of the public body. So here, it's really a discussion about the consideration of purchasing, selling, leasing, or the value of real property. So general discussions of land use are not appropriate for this purpose. Again, the chair has to make a declaration that discussions in open session would have a detrimental effect on the negotiating position of the public body. And they should also be identifying the specific piece of property that the public body plans to discuss, unless disclosure of that information would compromise the purpose. I'm going to skip over 7, but if there are any questions, I'm happy to answer them at the conclusion. So executive session purpose 8 allows the public body to consider or interview applicants for employment or appointment by a preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants. So here this purpose only applies to preliminary screening committees, which is essentially a subcommittee of a parent public body. So the preliminary screening committee cannot include a quorum of the parent public body. It can include some members, but it cannot include a quorum. The discussions in this executive session are for interviewing or screening candidates during a preliminary screening period. So this can include more than one round of interviews, but once you reach the finalist stage, any further discussions must be conducted in open session. And once you have obtained finalists, the screening committee has to submit more than one finalist to the parent public body who will be making the final decision. Because if you only submit one, then it's as if the entire interviewing process has happened behind closed doors. So you have to submit at least one or more. And again, here, this purpose also requires that the chair make a declaration that an open meeting would have a detrimental effect in obtaining qualified candidates. I'm going to skip over purposes 9 and 10 and go right to meeting minutes. So public bodies must create and maintain minutes of all meetings, so both executive and open session. And minutes must include the date, the time, the place of the meeting, and a list of members who were present or absent. Although our recommendation is you include the members who are present and absent. The open meeting law specifically only requires present or absent. The minutes also have to include a summary of the discussions on each topic. So it doesn't require a transcript, but it should include enough information so that a member of the public who didn't attend the meeting can read those minutes and understand what the public body discussed. So just one line that says a discussion ensued is not going to be sufficient. The minutes also have to include any decisions that are made and actions that are taken, including a record of all votes, including roll call votes. So secret ballots are specifically prohibited. And again, if you are in a meeting which requires roll call votes, that needs to be specifically identified in the minutes, which means each person's name must be listed with how they voted and not just simply unanimous with a number. Finally, the minutes have to include a list of documents or other exhibits that are used by a public body at a meeting. You don't need to attach those documents to the minutes, but the minutes have to at least include a list of the documents that the public body used during the meeting. And again, the minutes have to include the names of any members who are participating remotely. And this is probably important since a lot of public bodies have been and still are holding virtual meetings. Now, minutes have to be created and maintained for every meeting and have to be approved in a timely manner. And that means within 3 meetings or 30 days, whichever is later. Whichever of those 2 time periods is later is when the minutes must be approved. That's for both open and executive sessions. Again, documents and exhibits that are used by a public body, which generally means they're present, they're verbally identified, and they're discussed, have to be retained. They don't need to be physically stored with the meeting minutes, but at least retained in some fashion so that if someone makes a request for those documents, you can easily provide them. Now, if you receive a request for minutes, for open session minutes, you must respond to the request and provide minutes within 10 days. That's 10 calendar days. And open session minutes can be provided if they exist in either draft or approved form. So even if the open session minutes haven't been approved, but they exist in draft form, you have an obligation to provide those minutes when a request is received. Executive session minutes are a little different. They should be disclosed once the purpose for the executive session is over. But there might still be information in those minutes that could be redacted because of some kind of privilege. Meeting minutes must be maintained permanently. That is the retention period for minutes. For any other documents that you might have used during a meeting, I would consult the Secretary of State's office. They publish a retention schedule for documents. That's a very useful tool to have. And you can either check their website, I know it's listed on their website, or reach out to them to see what the retention for documents other than minutes would be. Now, for executive session minutes, you can withhold them while the purpose for the meeting is ongoing. However, you have to periodically review the minutes to determine if the purpose for the executive session still remains. And once you review the minutes and you make a determination, you have to make that announcement during the next meeting, your next open session meeting, and include that in the minutes themselves. So if you get a request for executive session minutes and you've already conducted this review, you need to respond to that request within 10 calendar days. So under the open meeting law, it's 10 calendar days, not 10 business days. And you would respond by either saying, yes, we've reviewed the minutes and they're available and here they are, or we reviewed the minutes, they're not ready for release yet. If you have not done that review when you receive a request, you have an obligation to do that review either at your next meeting or within 30 days, whichever comes first. You should still be responding to that request for minutes and explaining that you haven't done a review yet, but that you plan to do it at such and such a date. And then once you've done the review again, you have to make an announcement of whether or not the minutes can be released and include that in the minutes themselves. Now, generally, documents that are used by a public body during a meeting are considered to be a public record. And again, used typically means that they're present, that they're identified, and they're discussed. But there are two types of documents that do not have to be disclosed. One of them is materials that are used in a performance evaluation of an individual bearing on his or her professional competence that were not created by members of the public body. So, for example, if you are a school committee member and you're reviewing, you're conducting an evaluation of the superintendent, you as school committee members might create evaluations and you are discussing that as part of the evaluation process. Those evaluations that you as school committee members create and use are public. But perhaps you've received evaluations that were filled out by teachers who are not part of your committee. Those are the types of documents referred to here that would not be considered to be public and needed to be provided. The other type of material is those used in deliberations about employment or appointment of individuals, including applications and any type of supporting materials, but not resumes. So resumes have to be disclosed, but other types of documents do not. And so the final topic here before I stop talking and take questions is the complaint process. So this is, there's an administrative complaint process. This is the form that you can find on our website, whereby any person who alleges a public body to have violated the law must fill out this form in writing. It needs to be filed with the public body first, and it needs to be filed within 30 days of the alleged violation. So typically anything that happens in an open session is discoverable at the time it occurred, because anyone could have discovered it because it happened in open session. Those complaints need to be filed within 30 days of the date of that open session meeting. However, there might be a situation where you couldn't have discovered an allegation or a violation within 30 days of a meeting, particularly if it happened in executive session. You might not know of a violation until the executive session minutes have been released. So at that point, the 30 days would start running when you reasonably could have discovered the violation. So again, you need to fill out this form. It needs to be filed with the public body first. If you're filing it against a local public body, also file a copy with the town clerk. And you can find this form on our website. Now, once the complaint has been filed with the public body itself and the chair specifically has 14 business days to review and respond to the complaint. So the complaint must be distributed to all public body members. They must have a meeting and discuss this complaint within 14 business days. You can request an extension of time. If, for example, you're not meeting within the 14 business days, you can request an extension of time from our office. Simply send us an email explaining the situation. But you have to meet to review the complaint and decide what the response is. That decision could be that you're going to forward the response to legal counsel and delegate legal counsel to respond for you. But again, all of this must happen within 14 business days. Once the public body has responded, the response must be sent to the complainant as well as to our office. If the individual who filed the complaint is not satisfied with the response, they can request further review from the Attorney General's office. That request for review is filed with our office 30 days after the complaint has been filed with the public body. So it allows a period of time for hopefully the complainant and the public body to work together to come to some kind of resolution. Keep in mind, though, that in order for us, in order for a complaint to be finally timely filed with the Attorney General's office, that complaint has to be filed with us within 90 days of the date of the original alleged violation. We will only review allegations that were raised in the complaint itself. So any additional allegations or concerns that you might raise in your request for further review to us will not be reviewed. We might make a notation about it, but we would not find a violation because the public body only had the chance to respond to those specific allegations raised in the complaint. So that is what we focused on.
Carrie, this is Diane Proctor, and I just wanted you to note the timing.
Yes.
In order to get to everything, I know this is so helpful and so wonderful.
Yep, I have 2 more slides to go through, and then I will stop talking. Thank you.
You're terrific. This has been fantastic. Okay.
Just finally, we all complaints must be signed and dated. We do not accept anonymous complaints, and public bodies are not obligated to respond to anonymous complaints. We do consider the complaints to be a public record, and we would provide a copy of the complaint if we were asked to do so. So when it comes to our office, we review the complaint. We might, we'll conduct our investigation. We might request documents. We might ask to speak with members of the public body. We'll decide whether a violation has occurred, whether or not that violation might have been intentional, such that the public body has been previously warned of this violation and has done it again. We will issue a written decision, and then the public body has the right to appeal to Superior Court within 21 days of receiving a determination. The complainant doesn't have an automatic right of appeal. Unfortunately, it's only the public body itself. And finally, instead of the administrative complaint process, there's a separate judicial complaint process whereby an attorney general or 3 or more registered voters can initiate a civil action in Superior Court to enforce the open meeting law. So I'm not going to go over the review. What I will say is here is our website. These are the resources that you can find on our website. And then finally, maybe the most important slide is our contact information with our phone number and email. So at this point, I'm going to stop talking, and I'm happy to answer any questions.
Okay, Diane, let me know when you're ready.
Tanya is going to ask the formal questions which the league has formulated in advance. Thank you, Tanya.
Hi, thank you very much for this wonderful presentation, Carrie. And personally, I have many questions, probably more, but I will limit them and have and hope that everyone has a chance to ask their own questions. One is about minutes that gets a lot of attention in the community. And if after requesting of a public body that the minutes please be posted after the deadline has passed, if somebody wants to submit a complaint to the committee, how does the 30-day after the violation stipulation work? Because like it might be a year and the minutes aren't still there. So is that still a violation at that time?
So,
I would, yeah.
oh, sorry.
Shall I just do all the questions at once for efficiency? Or
I probably won't remember if you
okay,
them
please.
all. So if I can just answer each one and then you can go to the next one if that.
Sure.
So with respect to meeting minutes, so minutes under the open meeting law don't have to be posted to the website. That's not a requirement under the open meeting law, but they do need to be approved. So yes, if the minutes are not approved, the 30 days would continue to run. So if you're past the 30 days and the minutes haven't been approved, well, 3 meetings are 30 days, we consider that to continue to run. So you wouldn't run out of time, so to speak. If the minutes continue to not be approved in a timely manner, and it's been a year, you would still be within the time frame to approve the minutes because we consider that to be an ongoing violation and the 30 minutes would continue to run.
Thank you. You said that the focus groups are exempt from the open meeting law. However, if a focus group is formed in order to eventually advise a public body, does that make them a subcommittee even if like they are formed by a consultant or an administrator?
Yeah, so this is probably one of the most difficult questions we get, whether or not whether a group is a public body subject to the law. We recently issued a newsletter a couple of months ago on the difference between like an actual subcommittee and maybe a working group that was created by a town official, like a town manager. So I point everyone to check that out because it's a good explanation of what the difference is. But it really depends on how they were created. So if they were created by a public body and certain members were designated to go out and research and then report back to the public body, I think we consider that to be a subcommittee subject to the law. You know, if it's a group that voluntarily got together on their own and then eventually said, oh, we think this is useful, and we want to bring it to the Board of Selectmen, that probably is not a public body subject to the law. So, you know, every case is going to be different depending on how they got together and were created. So that's sort of my best general answer to that question. But if you have a specific question, you know, we're happy to try and answer it if you want to email us or call us directly.
Thank you. And the third one is about documents. Under the current law, do all the relevant documents need to be provided to the public at a meeting? And do documents that are prepared by a member of the public body then consider deliberation? In other words, is it assumed that it must contain their opinion? And do documents that are used in the evaluation of a public official be made public during the deliberation? And that's all the questions and that I'm going to ask for now. Thank you.
So with respect to the documents, providing them ahead of time, again, that's not a requirement under the open meeting law to provide documents that a public body plans to discuss or use. It's certainly best practice, and we encourage public bodies to do that if they can, but it's not required under the open meeting law. In terms of, you know, the documents being used and whether or not they're public, as I said, a document is considered used under the open meeting law if it's identified, if it's present and it's actually discussed. So that's considered used under the open meeting law, which means, yes, it's a public record and can't be withheld for any reason. And so that's really on if they're using it in an open meeting. If they're using it in an executive session, it's a little different because obviously there might be confidentiality concerns or public privacy concerns. However, what I would say is that if a public body uses a document in an open meeting, it's considered public. But there's sort of like a subtle distinction between what the open meeting law requires and then the public records law as well. So I think even if a document isn't necessarily used by the public body during an open session meeting, if it's been either created or received by that body, I think it's still a public record under the public records law and might need to be provided. It's just that maybe the public records exemptions would be applicable to withhold a portion of that if that's allowed. So that's sort of the distinction. Like I can certainly answer questions about the open meeting law with respect to public records. That's the public records division, that any questions about whether the law would allow redaction or withholding of certain documents. And then I think the final piece of that question was evaluations. And I think, yes, if a public body uses or discusses evaluations in open session, yes, under the open meeting law, they're considered public and need to be provided. But again, there's that, what's public under the open meeting law versus what's public under the public records law. And yes, it exists and we've used it, so it's a public record, but maybe we haven't actually discussed it in a meeting, so we don't have to provide the whole thing, for example, unredacted, but the public records law might allow some withholding of a portion of the document. So
Thank you very much.
That.
Thank you.
Thank you so much. And thank you, Tanya. Carlin has some questions from the chat box. Before we do those, I just want to recognize that our exquisite clerk, Kari Maitari, is in the audience today. And when you have questions, you can always start with Kari and then go on to Carrie. Tanya, you're terrific. Okay, Carlin, take it away.
Thank you, Diane. Diane, let me know when you want to do audience participation for the questions. I have easily enough to take up the rest of the time, but I don't think that's appropriate. So I'm going to prioritize the first 2 areas because I have 5 different areas. But let me know when you want me to stop asking questions so we can get audience participation, okay?
I think so many of the questions in the chat are pertinent and important. So why don't you?
And I'm happy to stay on past 11 if that's appropriate. So, I mean,
well, it would be lovely to record your responses to the questions in the chat. So go ahead, Carlin. Thank you.
Okay, first question. Can a chair decide that there will be no public participation?
Yes.
Okay, number 2. See, that was fast. Should a committee post their agenda earlier than 48 hours and then amend it? Or should a committee wait until they are close to the 48-hour mark before posting the agenda? Which is better?
I think our recommendation is to post as close to the 48 hours as possible, so as to eliminate the need to keep amending the agenda, so that you have really a set list of topics, because I think it can get confusing if you're continuing to amend. So I think best practice is to really post as close to the 48 hours and have the really set agenda topics that can be listed and not have to keep amending.
Great. Okay. This is a question from Lois. Town boards are now meeting remotely under an executive order issued because of COVID. Is there any plan to make remote participation rules more flexible after the emergency order is lifted? And this may go to pending legislation, or it may be other things. What do you think?
Yeah, we hope the answer to that question will be yes. My understanding is that there is some legislation in the works to allow for more flexible and the use of remote participation as it is now, because we are hearing from a lot of public body members and members of the public who really like this ability. So hopefully it will continue in some fashion in the future.
Great, thank you. This is a question from Stephanie. How are recordings considered, and if they can, what happens if they conflict with minutes of the meeting? In other words, which is the official record, the minutes of the meeting or the video recording?
The official record is the minutes. That's what the open meeting law requires, that written meeting minutes be created and maintained. We would not consider a recording to be the official record of a meeting because it is really a transcript of the meeting, which is fantastic, but the open meeting law only requires a summary of the discussions. So we consider written meeting minutes to be the official record. Although, you know, if you have questions about how long you need to be retaining recordings, I think that's something that would go to the secretary's office.
Okay. All right. This is a question from Vince. A citizen group is deliberating on a town meeting article. Are those citizen group deliberations covered by the open meeting law?
And I would say no, I wouldn't consider them to fall within the definition of public body. It sounds like if they're more like a focus group or just residents getting together to discuss on their own to make recommendations, I wouldn't consider them to be public bodies.
Okay, quick follow-up. What if that citizen deliberation group includes members of a particular public body? Then
this is one of those situations where we really have to know the specific facts of how that group is created. Like, did the public body itself take some action to create this group and include its own members, or are the members simply volunteering on their own time to get together and the public body itself took no action? That's, you know, those are the factors that we would look at to make a final determination.
Got it. Question about consent calendars for town meeting. Do documents included in a consent calendar, are they treated the same way as documents that are actually discussed? This is from Stefan.
So, I mean, if the question really relates to town meeting, that's outside the scope of the open meeting law, because anything that has to do with town meeting is specifically excluded under the open meeting law itself. So if I understood the question correctly, I don't think the open meeting law would apply if it's something to do with town meeting.
Okay, so just a quick clarification, then I know that Stefan wants to talk. Are you saying that anything that touches town meeting is excluded from the open meeting law?
Well, not necessarily. I mean, I know, you know, finance committees or select boards have discussions about budgetary issues and, you know, might receive documents with respect to those budgets. So those types of discussions that actually occur during meetings by public bodies subject to the open meeting law and use of those documents, you know, fall within the open meeting law would be considered to be documents that need to be provided upon request. So I guess that's the distinction that I would make. I mean, you know, obviously, again, like every question depends on every answer to every question depends on its own facts and circumstances. So a lot of times the answer is always like, it depends on what those specific facts are for me to give like a specific answer.
Got it. Stefan, you had a specific point follow-up. Go ahead, Stefan.
Yeah, I meant consent calendar for a select board meeting or a committee meeting, routine stuff like financial reports or payment vouchers or whatever. They just put it on a consent calendar. They don't discuss each and every one. I was not referring to town meeting.
Yeah, I guess with respect to that, I mean, I think that's again the distinction between the public records law and the open meeting law. So if something's simply on the consent, if something's simply listed on an agenda as the consent, and you're right, there is no discussion. It's like, okay, everything that's on the consent agenda, do I have a vote to approve it all? And it's sort of, you know, yes, we take a vote and it's all approved. So I'm not sure we would consider that to be discussed, like the documents to be used during a meeting, such that they fall within the open meeting laws requirement that those documents be public. But I certainly think they're public in the sense of being received and created by a public body, like they're public records that would need to be responded if a public records request was received. So that's the distinction I would make.
Got it. Okay, thank you, Stephanie. Thank you, Carrie. Here's a question from Julie regarding meeting minutes. When describing discussions, must the points include the names of the people who made those points?
So we haven't, we have sort of recommended that the minutes don't necessarily have to include the identities of everyone who speaks. However, if, there are sort of majority and minority opinions that have been sort of fully discussed, that yes, we encourage and would like to see identities included for majority and minority opinions. That's sort of best practice. I mean, we realize that, it's hard to include everyone who speaks, especially if they only speak for a short period of time. But if someone really makes a point that goes to the actual discussions that the public body is having, it is best to identify those specific individuals.
Okay, that makes sense. Another topic for on-site inspections. Regarding on-site inspections, have you had any specific issues that have arisen for planning boards, zoning boards of appeal, or historic district commissions in doing on-site inspections?
I mean, I can't say offhand that we've had issues with those specific types of public bodies in the sense of whether or not they continue to violate the open meeting law. I don't know that we get very many violations with respect to on-site inspections. I don't know if I've personally ever done a specific complaint that alleged a violation of an on-site inspection. I mean, usually it's really about deliberation outside of a properly posted meeting. But I can't say that, like someone has identified to us specific concerns with respect to those public bodies and on-site.
Got it. Okay, the last question that I have here, it regards sharing documents online in a Dropbox. What kind of issues have you seen arise in that context?
So usually the issues are with respect to whether or not a public body is deliberating because it occurs outside of an open meeting. It's usually that those drop boxes aren't available for members of the public to see what the public body is doing. So as I said before, you can certainly put things there for the public body to review ahead of time to educate themselves so that they're ready to discuss the documents during a meeting. The problem lies where you're putting documents which you want public body members to review and provide edits to or opinions on. That's where the deliberation occurs, especially if you have a quorum of members who are editing a document, providing their opinions where you can see their actual edits and opinions. And those are the types of things that we consider to be deliberation. It's occurring outside of a meeting and no one can follow it. And that's where the problems lie and the violation can occur.
Got it. Thank you, Carrie. Okay, Diane, how about if I turn this back over to you and for the next step?
We can't quite see everybody. We're not in, I'm not in gallery view. I don't know if I can get into gallery view, but are there questions that folks have? If so, raise your hand and I think you probably will leap to the front of the line. Susan Bates and then Ingrid Detweiler. So let's start with Susan Bates. Susan?
Thank you. And thanks for this very informative meeting. My question was a little tangential, but is there any movement to require the state legislation to follow at least some of the open meeting law rules?
That's a great question. Unfortunately, I don't know the answer. I don't know if there's legislation pending that would require them to do so. I think that's what a lot of people would like, because I don't think they're potentially subject to maybe even the public records law. So I know there's a lot of talk about that. I don't know whether any.
Susan, very clever question. Probing an appropriate question. Ingrid Detweiler.
I wondered, what are the rules for editing, for public body editing meeting minutes before they're approved?
So we think that editing minutes is also considered to be deliberation. So what we have said with respect to editing is that best practice is for either the chair or maybe an administrative assistant to send a draft, like a first draft can be sent to all public body members. If members want to edit those minutes, then they need to respond individually to either the chair or the administrative assistant. I mean, it's better for an administrative assistant if you have one to do it. Send any edits individually, because if you send your edits to a quorum, then we consider that to be deliberation. So the edits would need to be just sent back to one individual. That individual can compile those edits together, but that compiled and edited document cannot be shared with the public body outside of a meeting. So you would have to be sharing it during the actual meeting, and then you could have a discussion about, whether those minutes are accurate.
Thank you, Andrew, for that terrific question. Do you have a second question?
I guess my follow-up was also the extent to which the minutes could be edited, such as to possibly change what actually happened at the meeting.
So there's no prohibition on editing minutes. Like if, for example, you've approved the minutes and then you decide, oh, I think this was inaccurate. There's no prohibition from amending minutes after they have been approved. What our recommendation is that obviously that should be done during an open session meeting and a discussion, and that there should be a notation in the minutes themselves. Either the specific edits are highlighted in a different color, or there's, some kind of like bubble next to it that says these were amended on such and such a date. But there should be some kind of designation that those minutes have been edited after the fact. If you're editing minutes during a meeting, I mean, obviously minutes have to be an accurate representation of everything that occurred during a meeting. So what we have said is, we don't look at minutes to decide whether or not what was said is actually true, but that they're an accurate reflection of what occurred. So if, for example, as a basic example, someone said, well, the carpet is green and the carpet's actually blue, if the minutes reflect that the statement is that the carpet is green, that's an accurate reflection of what was said. It's not a true statement because the carpet is blue, but it is an accurate statement of what was said, and that's what the minutes need to include.
Fantastic.
Diana, saw a question from Henry Dane. It's also from Kari Tari.
Okay, Henry.
I would just like for you to confirm that the open meeting law never requires a public body to go into executive session, that it is always a matter that is optional to the body to do that.
Yes, that is true. A public body is never required to convene an executive session. It may do so if it would like to, if one of the 10 purposes are applicable, but it can always have a discussion in open session.
Because I think there's there may be a tendency that they frequently do because they can, rather than it's really the best idea to do business in an executive session. I'd also like to comment on I think the irony that was mentioned before, that the public body that created the open meeting law and the public body that enforces it, neither one of them is subject to the law that they either made or enforce.
I mean, I will say, that's true. I mean, we do have an open meeting law advisory commission that oversees sort of our enforcement. They are subject to the open meeting law. They're a public body, just like any other state public body. But I mean, Mara Healy is an individual public official, so she is not subject to the law herself.
Thank you so much. And Kari, my Tari, our own clerk.
Thank you. I just want to make a comment about posting agendas. The 48-hour deadline to post an agenda is for the public to be able to see it in more than, or at least 48 hours prior, not including weekends and holidays. That's not for the town clerk's office to get it for posting. So give us several hours to do that, because we are doing other things as well, and we might miss your deadline. So think of it as when you go online to check that it's posted 48 hours before, you will need to give us that extra time. Thank you.
Thank you for that reminder to be courteous. We all need every reminder of courtesy we can receive. Carrie, you've been fantastic.
Thank you.
There is so much to learn and so much to understand. Your command of this is exquisite.
There was a question.
Diane, there's a Kate. Kate also has a question.
I'm sorry, who else has a question?
Kate does, and then so does Tanya.
Okay, Tanya, go ahead, and then Kate, and then we've got to watch our timing because we're losing people who thought we would be right over at 11. So let's give ourselves 5 more minutes. And Tanya, you want to ask, and then.
No, I just wanted to point out that Kate had a question.
Tanya, I knew you'd be looking out for me. Thank you. My name is Kate McEnany. I'm a member of the planning board, and I really appreciate this opportunity. I think there's occasionally open meeting training, and I wasn't able to make any, and I was able to make this, and it's great. So I'm definitely coming at it from the perspective of really appreciating the intent of this, and but also seeing it from the side of being a member of the board and seeing and thinking that it's very chilling to collaborative conversations that would be happening outside of the meeting. Of our meetings, and therefore that just doesn't, those conversations and that work that would take place outside of the meetings simply doesn't happen. And so I see it definitely as an inefficiency, and so I'm coming from it from that perspective, not wanting to criticize the law or think that we should not have it, but just trying to understand how do we get this work done, while we're compliant with the open meeting laws. So I guess I just had, just from that point, just wanted to ask a couple of questions. So if we, and again, I'm a member of the planning board. So if we as a planning board are working on something like thinking about making a recommendation for a change to a zoning bylaw, and as we work up to that, we're trying to decide what it is we're going to propose, or we have a problem that we're trying to solve or to make better. And so we're going to do some work on that. We're going to outline, 5 alternatives, and we're, think about different ways to address those. If I did that with one of my colleagues on the planning board, is that a deliberation? Because it's not, discussing a matter that's up for approval, for example, project.
Well, if you're a 3-member public body and you're getting together with one other member, then it's a concern because now you're a quorum. We've said with respect to, deliberation is so broad that it doesn't just include, voting on a particular matter. It really is the expression of an opinion. So if your discussions, even if they don't result in any kind of decision or final, outcome, if it's something that you as a public body member if it's within your jurisdiction and the public body overall has the authority to make a decision on a zoning issue and these discussions relate to that, then I would say that it would be considered deliberation. And if it's among a quorum outside of a meeting, then it's problematic.
So if it's not among a quorum, it's not problematic, although we always say, well, there could be, then you're looking at something serial.
Yes, I mean, if it's not a quorum, as long as you're not a separate subcommittee, then technically less than a quorum can have the discussions. I mean, what I will say and what I've always said is that anytime public body members get together regardless of what you're discussing, there's always the appearance of impropriety. So you're always going to have someone in the community who sees members getting together secretly to discuss whatever it is and just assume that you're deliberating outside of a properly posted meeting. So just sort of like keep that in mind, for purposes of openness and transparency, that's what it could look like. But technically, if it's less than a quorum and you're not a subcommittee, you can have discussions outside of a meeting. But again, as you mentioned, always be aware of the possibility of then serial communication.
Hey, Brittany, I think the frustration we all feel to both support the open meeting law and conform to it at the same time. We have to stop, I'm afraid, given time. And Kate, don't hesitate to reach out to other people if you have questions. If this is all overwhelmed everybody, on Sunday, Tanya is performing at the Concord Public Library, a beautiful piano concert. So if you need your soul calmed and if you need to have some quiet, serene time, please go to the Concord Public Library and join Tanya at 3 o'clock this coming Sunday on Mother's Day. So for all of you who are mothers, want to be mothers, are thinking about mothers, have a wonderful Sunday. And Carrie, we are indebted to what you have provided for us. Thank you so very, very much.
Oh, you're welcome. Thank you. I'm glad.
Everybody have a wonderful holiday. Okay, bye-bye.
Bye, everyone.